good morning, good afternoon, good evening, wherever you're joining us from. My name is Dr. Eugenia Caternor, and I'll be your host for today's episode of Transformations Talk. Transformations Talk is a platform where we educate, we empower, we inspire, we uplift, and promote change within our communities. We share ideas, we share knowledge, our experiences, our insights on different topics, pertaining to life. We can give, advice, we can share experiences that we've had. You can also be a host or a speaker if you are interested in being part of the Transformation Talk community. We reach out to different peoples in the community to share their knowledge and experience with us. And today we are very pleased to have another speaker that I cannot wait to introduce. But in the meantime, if you need to share the link to your with your friends, please do so right now. You can share it, your neighbors, family members. You can join us on Zoom or on YouTube. And after the presentation, it's also going to be available on YouTube if you want to watch it later or watch it again or share with other people. You can also see the whole presentation on my website, dreugeniacaternor.net. You can email us, dreugeniacaternor@gmail.com. Our phone number is 443-623-6080. If you need to send us a text message on WhatsApp or regular text message, you can also give us a call. We're here to support each other. And thank you all for spending the time to join us over the last few months that we've been doing this. Your encouragement, your comments is really pushing us forward. People are reaching out to us, talking about how they're benefiting from this information that we've been sharing. So please keep sharing with other people because it can help somebody else. Today, we do have a special guest in our midst who is going to be talking to us. She's also a friend of mine. I've known Miss Davida for quite a while now, and she is in law. Now we're used to the healthcare stuff. Today, we're going into the law. So just relax, enjoy the presentation. Save your questions to the end so you can ask all the questions you want to ask. As we know, when it comes to legal matters, especially in America, we cannot play with it. Ignorance is not a reason to break the law. So it's very important that we all learn about the law pertaining to where we are in America. Okay, Ms. Davida Bortmes is, an attorney. She have her own practice in Maryland. She does family law, trust, estate, wills, criminal defense. Again, you don't know when you would need a lawyer, so please make sure you save her information somewhere because when you need it, I'm sure you can tell, hey, remember me? And she'd be like, no, I don't. And you can tell, listen, I was listening to you when you were on Dr. Eugenia's podcast, and she'll probably give you some discounts. So don't lose her number, save it somewhere. Okay. So with not much ado, I'm gonna introduce Miss Davida to our show today. Miss Davida, you are so welcome.
Oh, thank you so much. Thank you. Thank you for such a warm welcome, too.
You for accepting our invitation because this is an area where we don't talk about a lot. Personally, I don't, and I've had people call me. It's funny, somebody just texted me this week if I know anyone that does trust. She worded it differently, so I said, no, I don't. And I went back and started thinking about it again. I said, wait a minute, I know Miss Davida does. So go ahead, make sure you join us or watch later. And if you have any questions, you can ask. But I just want to say thank you for joining us today. And I pray that God is going to use you to be a blessing to everyone that is listening today. And if people have questions at the end, we'll be able to ask you some questions, you know. So my first question I want to ask you is to tell us a little bit about yourself and also how you got into this profession.
Well, first of all, thank you, like I said, for the warm welcome. I want to thank you and for inviting me on this platform, and for everybody that's listening and watching or will be watching in the future. And so I'm hoping that our hour can be enlightening and give information enough that when we walk away, we are richer for having participated in this discussion. As for me, law has always been in the background for me. So I was born in Ghana. I came to the United States when I was about 9 or 10 years old. And so I basically went to the end of elementary school, all of middle school and high school here. And I went to St. Mary's College in Maryland for undergrad. I did a double major in history and political science. So I've always been into writing, into reading, into figuring out how societies decide how to govern themselves, what policies they choose in order to make sure the society is safe and that it's a lawful society. So it's always been an interest of mine. And so from undergrad, I went to law school. I went to Syracuse Law School, and while I was there, I also did my master's in history. It just wouldn't let me go. I always, enjoyed that. Um, so after law school, I came back to Maryland. Maryland has always felt like home to me. Came back to Maryland, and I took the bar exam in 2005. And I was barred in December of 2005. So I've been practicing for almost 20 years, and about a couple of months here, it's maybe 20 years. um, and I'm sorry?
Congratulations.
Thank you. And in terms of the area of law, I like to say with the law that I practice is everyday law, it's practical law. It's law that people um, need on a daily basis or have questions about. It touches on different areas. I touch on tax, on real estate, on contracts, on criminal law, on wills, on trusts, guardianships, custody, child support, divorce. All these are questions that if you personally, don't have any questions or haven't gone through them, you have family members that have gone through that or, will go through that, at some point in the future. I always tell people, the older you get, the more likely you should have, at the very least, a will. I encourage people to do trusts, but at the very least, a will. But again, it's a practice area that encompasses a lot of different things. And so it keeps me on my toes because the laws are always changing, you're always learning, and you're always helpful because, again, this is everyday law. This is law that people use on a daily basis and they always have questions about. So,
Wow, that's very good. And I mean, you mentioned one thing, helping people, and I truly believe that whatever we're doing, that the motive should be helping people.
absolutely.
Impact that you're making on other people's lives, goes a long way. Because I mean, I'm from Ghana, and a lot of us are from other countries, and sometimes knowing the law that governs you where you live is very important.
Hmm. Hmm.
We live here, and if we don't know the law and something happens, listen, nobody will have mercy on you.
That's very true. And what you said is absolutely correct earlier, that ignorance of the law is no excuse. You are held to the same standard as if you've read every law book there ever was, right? So if you break the law, whether you knew it or not, it doesn't make a difference. So it's always very, very important to seek out, legal advice. I can't tell you how many clients try and do the self-help where they Google things online and then they file something and realize they filed the wrong thing or they're in trouble, and then I have to undo a lot of what they've tried to do, and sometimes that sets you back. So it's always a good idea to, at the very least, speak with somebody, in the area that you're concerned about.
Yeah, I truly believe so too, because I mean, like to stay in my lane. When it comes to healthcare, I do what I have to do. Anything beside healthcare, I make sure I find the right people that know what they're doing. And I
Mhm.
really applaud you for what you do, because I'm sure you've seen so many different scenarios, so many different cases, what would you say was one of your most challenging case over
Oh,
the
goodness.
3 years?
There's been so many over 19 and almost 20 years. There's been so many. Um, Some of my challenging cases are the longer trials. I think I had a custody case that lasted for 1 week, Monday through Friday, 8 hours a day or 7 hours a day, before a judge. I won't go into the details for confidentiality reasons, obviously, but that was an extremely trying case, and there were multiple kids involved with multiple needs. And so, and we had a best interest attorney that was assigned in order to make sure that the kids' needs are being taken into consideration. One of them had special needs, again, different ages also, and the parents were just not committed to any kind of mediation or resolution. So usually by the time it gets to a trial format, the court and the attorneys have done everything they can to try to sort of bring them back from the brink, to try and do mediation, to try and do some kind of collaborative, law or agreement, in order for it to settle amicably. But there are a lot of cases that just, the parties are in their corners, and they want the judge to make the best decision. But I always tell my clients that you know your child, especially in child custody cases, you know your child more than anybody can ever know your child. So it's always best to try and come up with a resolution. So anyway, but yeah, that case was about a week, a full week, Monday through Friday, 7 hours trial. So that was extremely exhausting. But I've had some rewarding cases that I've done that have gone to court where many years later, I will get a phone call at my office, and the voice on the other line is a child custody case I did, and it's the child grown up, and they just call to say, hey, I was just thinking of you the last, week or whatever, and I wanted to say hello. I can't tell you how many times that's happened, and it's very, very gratifying when I hear that, because you see the impact that you've made. You see that it was a positive, even though at the time it was very trying, it was a positive experience. And the fact that they're reaching out just to say hello, tells me that I did something right. So there are some challenges, but there are certainly some good that comes out of what I do.
Awesome, awesome. Anyway, and that's the bottom line.
Yeah. Hmm.
The outcome. So very good. Yeah. So yeah, so I'm just gonna let you have the floor or the stage and just pour into us, whatever you have to share with us today, please do. And I have one or two more questions that I'm gonna leave to the end. It's just a question that always baffles my mind. It has to do with the custody case. So I'm gonna let you speak, and when you finish, we'll open the floor if anybody have any questions, and then we will see if we have enough time. I can ask my questions.
Okay, I will share my screen here for
Yeah,
hopefully you can see this. Okay. Can you see this? Okay.
yeah, I can.
Okay, great. Yeah, so I just want to touch very briefly on a couple of different areas of law. Again, all of these areas of law, I could probably do a 2 hour, 3 hour seminar on subsections. But to just give your audience, a general idea of these areas, so if they have questions, they can ask it towards the end. Or if you have a question, as I go through, you can of course raise your hand, and I'll be happy to answer the question or put it into the chat. So family law, wills, and guardianship. Family law basically is just what I mentioned earlier. Anything that has to do with a familial relationship, which is divorce, custody, child support, all those areas. And then, of course, there's wills. And as I mentioned earlier, I think everybody should have at a minimum a will. And that is to make sure that as you get older, your wishes are really being met. And not only that, but that you are also able to set a guardian for any minor children or minor child you may be leaving behind if the worst is to happen. Dr. Caternor, of course, has introduced me very nicely, so there's no need to go through my bio here. But at the bottom here, the key topics I'm going to be focusing on: family, divorce, marital property distribution, wills, trust, and guardianships. Now, what is family law? Family law addresses legal issues that include, as I mentioned, divorce, marital property separation, child custody, and child support. Now, you don't have to be married to have some of these issues, right? If you were in a relationship and the relationship does not work out, obviously, and you have a child, then child custody may be an issue and child support may be an issue. However, if the relationship also included a marriage, obviously divorce might be an issue, and as well as marital property. So a lot of these are very private, sensitive information that people really don't like to talk about. But having practiced in a lot of the counties in Maryland, Montgomery County, Howard County, Anne Arundel, Prince George's County, and other counties, they all have very, very busy um, family law dockets, which tells me that a lot of people are going through this, or some variation of this is just not something that people want to talk about. So it's a very private matter. Um, but when it comes to family law, a lot of people don't seem to understand that whenever there is a marriage, anything that's acquired during the marriage is marital property, irrespective of how it's titled. So a lot of times I will get somebody that comes in here and says, oh, well, I have the house and it's mine because my name is on it. And the next question I always have to ask is, well, were you married when you purchased the house? Well, yeah, we bought that, we got married and then we bought the house. It doesn't matter if it's only your name on it or only your wife's name on it. That is marital property. And so I try to explain that, and that doesn't just go for the house. That could go for, the vehicle, that could go for joint bank accounts, anything that's acquired, even personal property, anything that's acquired during the marriage is subject to marital division. So again, all that is encompassed in family law. And when it comes to child custody, there's various factors that the court will look at to make a determination as to the best interest of the minor child or the minor children. Again, it's always best for people to try to resolve it, whether that's through mediation or collaborative law of some sort. But if they're not able to come to an agreement, like I said, I've gone to a lot of custody cases, and the courts always, require that the parties do parenting classes, will do mediation and things of that nature in order to make sure that the parties are really thinking about the long term. How are they going to co-parent? How are they going to get along? Especially when the child is young, they have at least 18 years or 15 years or however long that they have to get along. So family law is a very, very broad area. And again, I've kind of touched upon a little bit of all of this, obviously child custody and visitation, child support and modification. Child support is one of those areas that a lot of people have questions about as well. They're trying to figure out, well, what exactly is child support? How does the court come up with the amount of child support? And child support essentially is just based on the income of both parties. So the income of mom and the income of dad. And then they will look and also see if there are any expenses associated with the minor child. So if the child is in private school, if the child has extraordinary medical expenses, if the child is in extracurricular activities, dance, piano, football, basketball, tennis, all these activities that may cost is all calculated into the child support guidelines. And so from that it's literally a calculation where it comes down to a percentage of each parent's income and a percentage of the expenses, daycare costs, things like that. All that is factored in, and obviously a number is provided. And the person that does not have custody of the child will get child support. And child support in Maryland goes until the age of 18. And so once the child reaches 18 or graduates high school, whichever one comes later, because there are some kids that have later birth dates, the court will require child support be paid. And that's usually through wage withholding, meaning it will come out of their paycheck, or it can be, direct pay. But by the point parties are in child support proceedings, they usually don't trust the other party to just write a check, right? So a lot of times it will go through the Office of Child Support Enforcement. And that's how child support is done. Now, modification goes for both child support and custody as well. So once there's an initial determination of custody or support, and let's say some years go by, the child's need may change or the parent's income may change. If there's a substantial enough change in circumstance, then the parties can come back to the court to try to modify a prior court order. So that's what modification is. And also one of the things that people really didn't talk about is swept under the rug a lot are issues of domestic violence. And the courts always have a docket on a daily basis that if somebody is experiencing domestic violence and they're brave enough to come out and file for a protective order, then they will hear it, they will issue a protective order. Usually protective orders are for 1 year if it's granted. Sometimes it can be for longer, depending on the level of abuse the person is going through. So protective orders are also another avenue that's categorized under family law, even though it's not technically in the circuit court, it usually originates in the district court. All family law cases originate in the circuit court. Protective orders usually are in district court, but they can also be in circuit court. But that's another avenue. And then of course there's paternity and parental rights. I won't go into that too much, but that basically kind of goes in with the with custody. Usually, sometimes you have third party trying to assert parental rights like grandparents' rights and things of that nature. And then of course adoption and guardianship. And again, I won't go into that too much because again, that's another broad area. But obviously, adoption is where you are trying to expand your family or trying to have determination of a parental right. So that way you are able to take in a child that may not be biologically yours. And there is a process for that as well. And I've done a few adoptions recently that have gone very, very well. And then guardianship, as I mentioned before, if you have a will, you can always designate somebody to be a guardian for a minor child. And then there's also guardianship of a parent or even a grandparent, so there's minor children guardianship, and then there's the adult guardianship. And the adult guardianships are slightly different in that it has to do with somebody that is not able to take care of themselves, whether that's financially, they're being taken advantage of because they're just not mentally capable of doing that. So a lot of times you would have to petition the court for the guardianship of the person, meaning they can't take care of themselves, or a petition for the guardianship of the property, meaning that, they just are not paying their bills, they're not keeping up with the things that they need to do in life. Sometimes it will go together, guardianship of the person and the property, in case their health is failing. So that's where a lot of times something like a power of attorney might come in handy, which should be put into place, hopefully to avoid you having to go to court and fight potentially other family members for the guardianship of a person. I saw a hand up. I apologize if I couldn't get to you. You can unmute yourself and ask your question if you do have a question.
Yeah, hi. I wanted to ask about when you mentioned domestic violence. What is considered domestic violence in a home?
Yeah, and that's a good question. So domestic violence, especially when it comes to protective orders, is any intimate partner violence. So violence between two people who live together, that's boyfriend, girlfriend, it could be same-sex couple too, and spousal couple, so a husband and wife. Anybody that you have a sexual relationship with, basically, is what the statute includes. That's what they deem to be intimate partner violence. Anybody that goes through that process or is subjected to violence from the people in those categories, they will be eligible to file for a protective order. It doesn't have to be a physical pushing, punch or fight. Sometimes it could also include just threats of violence to make you, fear for your safety. It could also be stalking. So the statute, goes through, a long list of what constitutes or what would allow you to file for a protective order. And it's a fairly broad category. Essentially anything that an intimate partner puts you in fear of, whether that's actual threats or things that, is a pattern that you believe will lead to your safety being compromised. You'll be eligible for a protective order. Any other questions?
And what is the court looking at as far as proof when it comes to that? Because you did say a lot of people usually do not come out
Yeah.
or talk to anybody about it, and so there is no protective order in place. And so if in this case, if both parties are in court, what is the judge looking at? Like, is it just verbal, and or what are some of the proofs that they're looking at?
Mm-hmm. So yeah, that's also a good question. So a lot of it is based on your testimony or the other party's testimony. Now, every case is a little bit different. Sometimes if the violence occurs in the home and there are no witnesses, then it just becomes whose story holds together better. Meaning, okay, what were you doing? What did you do next? And then what happened, right? You have to walk the court through what happened, and then the court will ask the other person, okay, what happened, right? And then the judge will have to make a determination of basically whose story they believe, over the other. This is assuming there's no marks, there's no witnesses, there's no 911 call. Like if there's absolutely no evidence whatsoever. Usually when somebody has gone through that process, usually there's, some mark or there's some witness. There's Ring doorbells are a big deal now that people use in a lot of the protective order cases. So when you come in for a protective order, as long as your testimony is credible, you have a very good chance of the court granting that protective order. Protective orders are for 1 year. And like I said, it could be extended in case the person violates the protective order in the meantime. So, and the proof for a protective order is not like a proof like like a criminal case, beyond a reasonable doubt. The proof has to be basically 51% or 50.1. So as long as the judge believes you more than the other person by even 0.1, right? Then you will get the protective order. And that's for cases where both parties are really saying no. Like one person is saying something happened, the other person is saying nothing happened, right? Where the court has to have a whole hearing on the protective order. Sometimes the other option the court will give parties would be, do you want to consent to a protective order, right? Meaning you come in complaining of a situation and the other party says, I didn't do anything. Then the court would say, okay, well, if you didn't do anything, would you consent to stay away from this person? Right? And some people will say, yeah, I have no problem staying away from this person. And that is basically a consent, a consent order, but it's a protective order. It has the same protections as if you went through the whole legal process. The only difference is if you consent, you have a better chance of it not remaining, on your record, forever, right? So there's some built-in things in order to allow the person that comes in for the protective order to get it without there having to be a long hearing. Does that answer your question?
Yes, ma'am. Thank you.
Afua, I see that your hand is up. So, okay, if no questions, I'll move on. Now I'll go through this. I know we're short on time here. But when it comes to, I think I was finishing up divorce and marital asset distribution. I was mentioning that earlier. So when a marriage ends, a lot of time the courts require it's more equitable distribution of marital property. I say fair here, but the right legal word is equitable distribution of marital property. And, people assume 50-50, she'll get 50%, I'll get 50%, we go our separate ways. And usually that's what happens. But every now and then the situation of the parties during the marriage is such that one person should get a little bit more than the other. Maybe one of them was a housewife and never really worked outside the home, or even a house husband never worked outside the home. And so one party is the one that's making all of the income. And so the court has to look at it and determine, will this person be made whole if we split, these assets 50-50, or does this person deserve just a little bit more, maybe 55% to 45%, right? And again, when it comes to marital distribution, parties can agree to whatever they want. I'm talking only in regards to what comes before a judge for a division. And then, and like I said, yeah, the economic circumstances of the party, makes a big difference. Now, the other question I get a lot is alimony. One question I get a lot is child support. The other is alimony. And when it comes to alimony, which is basically spousal support, using the last example from the prior slide, if one spouse has been a stay-at-home wife for a really long time and the other spouse has been working, outside the home, then in the event of a separation, the person that's been working inside the home or raising the family typically will have the lower earning capacity because they've been outside of the workforce for 5, 10, 15, 20 years. And the person that's been working outside the home has been able to move forward in their career, and they tend to have a more stable income. So because of that, if a divorce is to happen, then alimony will become an issue. And when it comes to alimony, there's different types of alimony. There's temporary, meaning 1 or 2 years that this person might need, maybe complete a program or a certification, and then they'll be back to earning a decent salary for them to be able to sustain themselves. Or it will be indefinite alimony, which is where maybe a marriage of 40 years, there's no way wife or husband, if they've been home the whole 40 years, there's no way really that they can get up to speed, due to age, due to time, that they won't be able to be completely self-sustaining like they were when they were married or even close to it. And of course, alimony can also be by agreement. But typically, the court will look at the factors of income disparity between the parties. And just because one person makes, I don't know, $300,000 and the other one makes like 150, it doesn't mean that they're going to qualify for alimony, even though there is a disparity in income. The court will look at the higher income person's ability to pay, and then the lower income person's need for alimony. So somebody might be extremely frugal. They just like the simple things in life. They make $50,000 a year. And if the financial statement they provide the court says that they can live on $50,000, not to their detriment, then alimony would not be awarded because they're able to be sustaining at, let's say, at 50,000 versus their husband at, let's say, 150,000 or something like that. So alimony is not always automatic. It's based on your need for it, and also based on the circumstances and your economic ability to sustain yourself, now and in the future. So I know I've been talking a lot about domestic cases. So I'll kind of switch a little bit here and go to guardianships and wills. Are there any questions based on the first set of slides that I went through?
I have a question.
Sure.
What about say if one of the spouses during the course of the marriage comes into property through a will, inheritance, then they divorce?
Yeah, that's also a very good question. So there are exceptions to marital property. Gifts and inheritance property do not qualify as marital property. Now, people have to be very careful about that. So for example, if you were to have a property, let's say you bought a house when you were 25, and you've had the house for a long time, and then you get married. And when you marry, you buy a house together. The house that you had at 25, that's premarital property. So husband cannot, or wife, whoever, the other spouse cannot get that property. It's premarital property. That's an exception also, right, to the marital property laws. The same thing with inherited property. So if somebody were to pass away in your family or friend or whoever, and they leave behind, let's say money or property, and they say that it goes to you, it's yours. It's your separate property. Now, the caveat there is that you cannot commingle that property, that gift, or that premarital property, or that inheritance with marital property. So, for example, somebody were to, to pass away, leave you $100,000 as, as your inheritance, and then you take that money and you deposit it into the joint account, into you and your husband or you and your wife's joint account. Now it's no longer separate property. Even though it's inherited property, you've commingled it, you've mixed it in with marital property. So once you mix it in with marital property, it loses its protection. So in order for you to be able to keep premarital property, right? So if you were to sell your house that you bought at 25 and then put that money into, the joint account, it's no longer premarital, property. Now it's marital property. The same way if you were to, get money through an inheritance and then, buy a house and then put your husband's name on it or something like that, or buy a house and put your wife's name on it. Again, it's the same idea. Whenever you mix things together, then it's automatically, it becomes marital property.
Thank you.
Sure. And I'm looking at the chats here. So I'm looking at a question here about if there's a marriage, that if you've been married for more than 10 years, you've had children, but you're not married in the United States, but only, back home, in case of a separation, can the partner still file for spousal support? Yes, as long as you're married somewhere, you're married. So if you're married in, wherever you come from, and you continue living together as husband and wife, you file joint taxes, you hold yourself out as being married because you're married back home, then yeah, then you can file for a divorce in the United States. You can file for spousal support in the United States. You have the same protection because you're married. If you're not married at all, or if there's some, like some people have customary marriages and all that where there's no paperwork, those are a little bit harder. Those may be sort of long-term engagements and not real marriages, right? Depending on how it's done. But if you do have paperwork, if you are married, it doesn't matter where you got married, you'll be eligible under the family law. Under the family law rules to be able to ask for division of marital property, division of assets. And the one thing I did forget to mention, division of assets also includes 401ks, Roth IRAs, retirement funds, pensions, TSP in case the other spouse works for the federal government through savings plan. So again, anything that is acquired, as long as you're married, whether you're married here or somewhere else, it doesn't make a difference. You have those protections. And then the other question I have here is what happens when a non-custodial parent is not paying child support, even though child support has been ordered, I believe, I think is what she probably meant or he meant. So then you would have to petition for contempt, depending on how they're supposed to pay for child support. So if they're paying for child support through the Office of Child Support Enforcement, a lot of times child support enforcement is keeping track of how much money is coming in or what months they've skipped and all of that. And if it happens long enough, they can suspend the license. They can actually also garnish any tax returns that they might have. And so let's say it's the father not paying support, they will be able to garnish, let's say he gets $3,000, tax return, they will be able to garnish that and then apply that to the child support that they're not paying. Now, if it's just an agreement between two people, then you would most likely have to petition the court to formalize it. So that way you can get a court order to force child support. And the other thing for child support, I get this question a lot too, is child support ends at the age of 18, but I've had people that separate, they don't file for child support. Let's say they separate when the child is 5 years old, and they don't file for child support until the child is 10 years old. And they expect to get child support from the time of separation, from when they separated when the child was 5 years old. And I always tell them, no, child support starts when you file. So if you separated when the child was 5 years old and you don't make a request for a child support until the child is 16 years old, you only get child support from, the time of filing, from that 16-year-old up until 18. It's not retroactive to the expenses and all of that that you may have incurred from the time of separation up until let's say age 16. So if child support is something that you feel your child needs, and again, child support is not really for you, it's for the minor child. I think a lot of people that do pay child support don't quite understand that. It's for the continued support of the minor child because children are expensive. And so you always have to make sure that if you are going to file, you don't wait 2, 3, 4, 5 years, because then those years you can't recover child support for those years. And then the last question, another question is, if a spouse makes less than you, but you take care of the kids and mostly all the bills, can child support still be obtained? Yes, child support can be obtained as long as there's a demonstration that you're caring for the minor child or the minor children. Whoever has custody, irrespective of income, will be eligible to petition the court or to go through the Office of Child Support Enforcement. So if you don't want to go through the court, you can always go to the child support agency in your county. So if you're in Montgomery County, you would go to the Montgomery County Office of Child Support Enforcement. Baltimore County or Anne Arundel County, every county has a child support office. So if you're not able to afford an attorney or you don't know what the process looks like, you can always go to the Office of Child Support Enforcement, fill out the paperwork. They'll make an appointment with you. They'll go through what your needs might be, and they would check your eligibility for child support to make sure you actually have custody of the kids, or at least the kids live with you, which is a presumption of custody. And then you will be able to make that request. And like I said, child support is based on income. So even if you make more income than the other person, you will still get child support. It would just be, maybe not as much because your income is more, right? But you will still be able to get child support because it's a percentage of each person's income that goes towards the minor kids. And I'll just take one question and then I'll move on. This question says, is it at the time of filing or the time the spouse was served to pay? So I don't quite understand. I think what you're trying to say is child support, does it start at the time of filing or the time that the spouse has to pay, I think. So child support starts at the time of filing. So let's say that you file child support in January, say January 1st, 2025, and then you don't go to court till June for some reason, 2025. And let's say child support ends up being $1,000 a month or something like that, in June, once the case goes to court. That child support of $1,000 will date all the way back to January 2025 when you first filed. So the person will actually be technically in arrears of like 5 months, right? From January all the way to, I guess, May or June, depending on when the court, passes the order. So child support dates back from the date of filing. That's why I always tell my clients that if you want child support, it's better to file it because it dates back to when you file, rather than waiting until you have everything set up just so, because those months are going and you can never recover support for the months that you haven't filed or that you didn't file. And child support, I can't speak to every state because I'm barred in Maryland, but typically the process is very similar. But I have to be careful, what I say about other states and what they do. But just generally speaking, child support is a very similar process throughout the United States. Yes. Okay. So let's see, I know we're running short on time here, so I will kind of skip ahead a little bit to the wills and the guardianship. As I mentioned before, so for wills, I always tell my clients that when you're doing a will, you want to sort of do a mini estate plan along with that. It's always good to do, a trust and, and all these other things. But if you're not ready for that, if you do a will, which basically tells your family or your loved ones where your personal items will go, where your property will go, who gets what of your personal property, of your real property, of your assets, insurance, your pension, even Social Security, things like that. All that can be put into the will in addition to who you want to inherit your property. So this allows you some say in where your property goes. If you die intestate, which is a person who dies with no will, it's called a person who dies intestate. If you die without a will, then the state already has a list of people that will get your assets. So they literally will go down the list of who should be in line. So they determine for you. So there's a list of predetermined people that will inherit from you if you die without a will, right? But if you die testate, if you die with a will, then you obviously have the control to decide who gets your things afterwards. And also you're able to appoint a guardian. If you have something like a trust, for example, not only will you determine who gets your assets, but you will be able to even determine, what your grandchildren might get. And sometimes even your great grandchildren, you're able to sort of, I call it controlling from the grave. You're able to kind of tell not only your kids what to do with the money you're leaving them, but your grandchildren even, and you're able to say, okay, at the age of 20, you can do this. At the age of 30, you can do this. So you really can almost not set behavior, but you can almost try to correct behavior from beyond the grave if you do a trust versus, let's say, a will. But if you're not ready for that, like I said, a will is generally good to at least start to have something in place. And I always say that you should also try and do a medical directive, a power of attorney, because those are things, then again, as you get older, it's not something that you want to think about, but if something were to happen to you, who will be able to take care of your affairs? Let's say you're incapacitated in the hospital, for let's say 2 months, something were to happen, who can take care of your affairs, pay your bills for you, take out money from the bank, pay the mortgage, speak with the mortgage company, or sell property if God forbid it's so bad that you're not able to return to what you were doing before. So, and I call it a mini estate plan, in that if you do a will, a medical directive, power of attorney, you're at least, getting some aspects of your affairs in order. And as I mentioned before, guardianships, they help protect minors or incapacitated adults. So if a grandparent or a mother or even a family member, something were to happen to them and they're not able to help themselves, you would have to petition. If a power of attorney, for example, you would have to petition the court in order to get guardianship of them. Otherwise, you have no legal say in what happens to them, right? So I think guardianships are also very, very important. I'm going to end there. I know I kind of went through very quickly a lot of law, but here's my contact information. I'll leave it up here in case anybody has questions over what we went over this evening, in case I'm not able to answer your question before we get off this call here. You can call the office. You can, of course, email me as well if you have any follow-up questions, or if you have very specific questions pertaining to your personal situation, you can, of course, call for a full consult. So are there any questions? I know I was answering some earlier, and I don't think I got to everybody, but.
If hello.
Yes, yes.
Yeah, can I ask you this question? Because a friend of mine was talking about it yesterday.
Sure.
She said, if you live with somebody for so many years, like probably let's say 10 years or 15 years, and then they have not married you, and then the person died, what happened?
So in Maryland, there's no such thing as common law marriage. So whether you were together for 10 days or for 10 years, you're basically treated the same. You don't have any protection. The only difference is that I guess the longer you are together with somebody, the more likely you might have maybe joint accounts. Maybe you purchased a home together or purchased a car with both of your names on it, something like that. That would be the only, real protection that you might have. If they don't have or if they do have a will, for example, and they named you in it, then you're protected that way. But if they die without a will, then again, the state has a list of who gets it. And you may not be on it as just, let's say, a girlfriend or something like that. But your child may be on it. Typically a child under the age of 18, will get 50% of the assets. Again, that's typical, right? 50% of the asset of the person that passes away, assuming they pass away without a will. And then from there, the state, will go down the list of who's next. However, if you were a wife, for example, typically it would be 50% to the wife and then 50% to a child under the age of 18, right? So you have a little bit more protection if you are married, just because the law has it built in, protections for marital for spouses. But if you are living together for a long period of time, short of him, having a will and then naming you, you really don't have any protection.
Thank you.
And another person asked, is it the same case if you're engaged as well? Yes, it's the same thing. Until you get that marriage certificate, whether you're engaged for a day or 10 years or 5 years, you're still in that same position. Yeah. The one thing that I wanted to talk really quickly about is the probate process. It's a long process, but I'm going to kind of give you just a few facts on it. If you have a will and you name somebody in the will, you also have to name what's called a personal representative, somebody that will make sure that your wishes are followed, right? But every will has to go through a probate process, meaning it has to go through a court process. That takes anywhere from, I don't know, 6 months to a year, depending on what the assets are, and whether or not people are fighting over certain things, But during this probate process is when, the wife will get their percentage, where the child will get their percentage, and, things like that. So at the very least, those people who are named, will be protected. So whether or not you're married at that point won't make a difference. If there's a will, then at least you're protected based on what the person left behind. Any other questions?
I have one, but it's on adoption.
Okay, sure.
What is the process like?
So it depends on the kind of adoption you want to do. So I'll just speak generally. So generally speaking, whenever you want to adopt a person, it's presumed that the person you're adopting either has no parents or the parents have given them up, right? And so you have to go through a legal process where you have to terminate the parental rights of that person. So let's take a fictional, I don't know, 5-year-old, and let's say they've been abandoned, right? You can petition to get temporary custody of them or guardianship of that child. So that way the child will be able to register for school and be taken care of while the legal process, is going through. Typically when I do an adoption, I would do a custody, a temporary custody while the adoption is going through. Because the adoption it could be a long process. I think the last one I did wasn't too long, maybe like 4 to 6 months or so. So it wasn't too bad. Only because we were trying to find out who the father or where the father was. Because if you know if the parents are alive, you have to get the consent of each parent. to basically give up, their parental rights. Because once the child is adopted, you can change their birth certificate to reflect your name on there. So it's almost as if the birth parents not never existed, but they're basically kind of erased, from that child's legal future. So whenever you're doing an adoption, first you have to make sure that there is some kind of agreement that yes, they're going to give up their parental rights, and they have, and they have the right to an attorney as well, and then they will sign away their parental rights. You go through the process of petitioning the court. The court will usually ask for, again, depending on the child, on the age of the child, but they will typically look to see if you're able to sustain the child. Are you employed? So they'll ask for tax returns. They'll ask for medical records to make sure you're healthy enough to be able to raise this child, to maturity. Are you married? Will your husband be joining in on the petition for adoption? So it's just a list of things that the court will ask of you, and that'll be part of the initial petition. So the initial petition is probably where you do the heavy lifting, because you have to get all these things in order. You have to get a physical to make sure that you're in good physical condition, at the time of the filing. And then once you file, it goes to the court. The court will look through it to make sure that, the proper signatures have been provided, and that the parents have given, have signed away their parental rights, and that you and your spouse, or you alone, depending, that you're qualified to be able to care for this child to maturity. If all that, checks out, then the court will put it in for a hearing, and then you appear. Either your attorney or the judge will ask you a series of questions to make sure that nothing really has changed from your petition, and that there hasn't been any change in circumstance with the child. You haven't changed your mind or anything like that, or that the parents haven't hired an attorney to fight you on what you thought was going to be an uncontested adoption. And then you go through, and you go through the hearing, and at the end of the hearing, you will basically get an order basically saying that your petition for adoption has been granted, and you're going to use that order to change the birth certificate of the minor child, or the child's last name to match yours, or even the child's full name, really, depending on how old the child is. So that's the typical process.
Is there an age limit?
No, you can actually do adult adoption. So there is no age limit. You can actually adopt an adult, a 25-year-old or 35-year-old. Yeah. So there's no age limit.
You can adopt a 25-year-old?
Yes, you can adopt an adult. Yes.
Oh, wow.
Yeah.
And how old do you have to be, the adoptee?
There really isn't a limit. I think the oldest I've had a grandparent adopt a grandchild when their child passed away, and the father was never in the picture. I think they were in their early 60s, and it wasn't a problem. I think that's the oldest I've done is 60, 62, something like that.
Okay. Thank you.
Sure.
I know there's couple more questions in there.
Yeah, I'm looking at it now.
Right before that, back to the adoption, do you also work with like adopting someone, let's say from Ghana or Africa or any other country?
Yeah, I have not done that because of the immigration aspects of it. I don't do immigration. There's another attorney that I work with when there are immigration aspects of it. But right now, I don't offer that.
Okay, thank you.
And there was a question, if I could speak a little bit about guardian ad litem, how it works for children during custody and visitation. So a guardian ad litem is basically an attorney that is assigned specifically for the minor child. So the same way for, in a custody case, there's an attorney for mom, an attorney for dad. The child sometimes will have an attorney as well. And it could be for a limited reason, like if a child is in therapy, or there are some medical issues, the guardian ad litem will be the one to basically make sure that that information, because it's privileged information, is not meant for public consumption. So sometimes the court will request a guardian ad litem for a very specific, limited reason, to be able to look at the medical records to see if it should be released, or to look at the therapy records or therapy notes to see if it should be released. So a guardian ad litem essentially is just an attorney for the minor child during a custody hearing to make sure that the minor child is protected. And is it a court's responsibility to offer that to the children? Again, it depends on what the child's situation is. Most cases don't have guardian ad litems or best interest attorneys. It just depends on individual situation. Family law is very personal to each family. Everybody's situation is a little bit different. So it really depends on what the issue before the court is. But if there is an issue that the court believes a guardian ad litem is necessary, then yes, they will appoint one.
Wow, that was great. That's good information. I feel
Good,
like
I'm glad.
keep going and going for the whole evening if we allow it. So, Ms. Davida, thank you so much for the presentation. You know, and thank everyone for joining in. Thank you for all your questions. This is really, really good information. And somebody's asking if we can contact you. Yes, absolutely. Can you please put your information
Yes.
slide up again? So the question I have for that is, I know you say you're licensed in Maryland. What if someone is outside of Maryland, maybe Virginia, DC, Delaware, and need your services? Would you still be able to see them if they come to you in Maryland?
I am only licensed in Maryland, so if your case is in Maryland, then I can represent or I can give you a consult or legal advice. But if your case is outside of Maryland, then I cannot give you legal advice because again, each county and each state, I'm sorry, not each county, each state is a little bit different. And I'm not licensed in those states.
Oh, okay. All right. But I'm sure you can give us referrals.
Of
If-
course, yes. I do have people that I've worked with that I refer in DC and Virginia
Okay.
and even
Well,
in New Jersey, actually. Yeah.
can that be based on a case? So for instance, somebody want to do the trust or will and they come to you in Maryland, like if I'm in Delaware, if I want to come to you in Maryland to get that services, would that be possible or no?
Yes, it's possible, but I always advise to get because wills, I'm sorry, trusts, they're fairly about 80% most likely, similar. But there are some oddities in certain states. So I would say that you most likely would be better off getting an attorney in your state to draft a trust or to draft a will. However, once it's drafted, it will take effect or it can be effective wherever. So if you're in Delaware and you do a trust and you move to California, it will still be given, full credit. So it's not like, okay, I did a trust in Delaware, I pass away, let's say in Texas or something like that. Does the trust still hold, right? So yes, it does. Once it's done, it's effective wherever. But I would advise to get an attorney in your particular state if you're going to do a trust.
Okay.
But other attorneys are not prohibited from doing it. So hopefully that answers your question. So other attorneys can do it, but I think it's better to come from your own state.
Okay. What about the online ones? I know there's a lot of online program. I know there's one.
Yeah, that's a pet peeve of mine.
Mm, it's not teddy bear. It's something.
Yeah.
Yeah.
Yes.
Yeah. you know.
I don't recommend them, but obviously, if you feel that's the only thing or if you feel like you want to do that, I can't stop you from doing it. I always say, at the very least, do a consultation with an attorney, just so you know what you're getting from the online versus what you might get from an attorney that is experienced in that area. Because online is very generic. When you do something, whether it's a will, a medical directive, or trust, whatever, is very much tailored to you. And there may be questions the individual attorney can ask you that you didn't think about. Because if you do something online, it's very much a template. They ask you, do you have this or do you have that? And they basically create it based on certain things, which may be limiting to you. But you may have more things that you want to add, and you really don't understand what kind of protections you're giving up if you don't do if it's not properly formed or put together.
That makes sense. Thank you so much. Well, Ms. Davida's information is on the screen. Take a screenshot of it. You can always call her, text her, email her if you have any questions, or if you know anyone that would need or may need her services, please share the information. This are information that we always need to have. It's almost like you dialing 911, because you never know. You never know when you would need any of these services for yourself, for a neighbor, for a friend, a co-worker. So please make sure you save this information somewhere important. Well, thank you so much. I've learned so much from your presentation. Yes, I still have questions, but I know our time is fast spent, so I will call you and ask some of the questions I have. And maybe our next episode is also going to be on law. That's 2 weeks from now on the 23rd. We're going to have another lawyer talking to us about immigration cases or immigration law. So please share the flyer with people that you know. I mean, because you don't know who is going to benefit from it or not. So just share. Anyone who is interested can join. You can always go back and visit our website or go to the YouTube channel and watch it or share with people around you, because these are very, very essential information. And from what I've heard throughout this presentation is at least get a will. I used to make a joke that I don't have anything to be having a will. But I know even if you don't have anything, you have something. You have
Mhm.
a bank account, you may have a house, you have something that you can put on the will, and who should inherit those um, assets, and also power of an attorney. I'm in the medical field and I've seen some really, really nasty cases of decision making. It doesn't matter how old you are. We all need to have a power of attorney. We all need, you know, um,
Medical directive.
medical directive.
Mhm.
So if you cannot make decision for yourself, I mean, it could be from anything, then at least the people that are making decision for you that you trust the most are making the best decision for you. If not, your enemies will make decisions for you. You don't want that, because
Mhm.
I don't think they want you here. They want you gone so they can take your property. So don't allow other people that you don't like or don't like you to be making decisions for you. So make sure at least you have that. If you have a lawyer that can do it, great. If you don't, please reach out to Ms. Bortmes, and I'm sure she can guide you and direct you to the right person or right places to go and have it done. Well, thank you so much. I'm very, very grateful for your time. I know you're busy, just as myself. So I don't take this for granted. I really appreciate your presence here this evening and all the helpful information, all the knowledge that you've shared with us. And I pray that, if anything should happen where we need services, we will always remember you. We'll always reach out to you, and
But
you can guide us.
Well, thank you. Thank you so much for allowing me to share this information on the platform. And I appreciate everybody that has asked questions. Again, I have my information here. If you want to follow up with anything that was said here today, or you didn't get a chance to ask your question, feel free to email or call. Again, thank you for taking this evening to listen.
All right. Thank you too. And good night, everyone. I'll see you again in 2 weeks on the 23rd at the same time, 8 o'clock. And again, we're still talking about law this month. So we'll have an immigration lawyer to talk to us about immigration law, because there's so much we need to learn, not only to help us, but also to help the people around us. Or you never know who may benefit from that information. So you come and listen, you come and learn, so you can also share the knowledge with other people. Okay. So for now, I'll say thank you all for joining and have a good evening.
All right.
Me
Good
too.
night.
Thank you.
Thank you.
You're welcome. Good night.